Welcome to Legal on Demand, powered by Maguire Legal. Conversations on law, business, and the decisions that matter. I'm Sonia.
And I'm Eda. In this episode, we're talking about one of the biggest misconceptions we still see from employers, and that's the idea that probation somehow protects a business from legal claims.
And it's usually framed like this: they're still on probation, so we can just let them go. But the reality is far more complicated. Probation can be used operationally, but legally it doesn't create a risk-free period for employers. So keep listening to find out how employers can get tripped up.
One thing a lot of employers are surprised to learn is that probation itself isn't something specifically created by the Fair Work Act 2009. Probation is simply a contractual arrangement. It gives the employer an opportunity to assess whether the employee is suitable for the role during the early stages of employment.
And from a practical perspective, that makes sense. Businesses are assessing performance, reliability, communication, and whether someone fits in operationally into the team.
But where employers get into trouble is assuming probation automatically removes legal exposure if the employment relationship doesn't work out. And a lot of that misunderstanding comes from unfair dismissal laws. Employers know there's a minimum employment period before an employee can bring an unfair dismissal application, and that's generally 6 months or 12 months for small business employers.
So businesses often connect that minimum employment period with probation and assume that they're two effectively the same thing, which leads to the mindset of if they're under probation, they're protected.
But that's where the real problem starts because unfair dismissal is only one part of the legal framework. This is the area employers often underestimate, and that's general protections claims under the Fair Work Act. Because unlike unfair dismissals, there's no minimum employment period for those claims. An employee can bring a general protections application very early into employment.
Yep, sometimes within weeks. And these claims arise where an employee alleges they were dismissed because they exercised a workplace right or engaged in protected conduct.
This is a scenario we often see in practice, and that's an employee starts employment, raises concerns about something internally. Maybe it was payroll, workload, maybe even workplace behavior or safety. And then not long afterwards, their employment is terminated during the probation period.
From the employer's perspective, they may genuinely believe the issue was performance, attitude, or a lack of suitability for the role. But legally, timing becomes important.
Timing is very important to establish connection because once an employee alleges the dismissal was connected to a complaint or workplace right, the employer may suddenly be defending a general protections claim rather than a straightforward probation termination.
One of the biggest challenges from employers in these claims is the reverse onus of proof, isn't it?
Yes, this is a huge feature of the general protections jurisdiction. Once the employee alleges a prohibited reason, the employer effectively has to prove that reason did not form part of the decision-making process. And that's where weak documentation really becomes a big issue.
One of the most common things we see is employers relying on vague language like not a good fit or not aligned culturally. The difficulty in those explanations are that they're often too broad to properly defend later on, especially if there's very little evidence showing what actual concerns were.
If there are no documented conversations, no feedback, no examples of performance concerns, then it becomes much harder to demonstrate that decision was genuinely unrelated to protected conduct. Another misconception is that employers don't really need process during probation.
And that's a big mistake. The process may not look identical to managing a long term employee, but employers should still communicate concerns clearly, provide feedback where appropriate, and ensure decisions are properly reasoned, because probation does not remove the obligation to act lawfully.
Small businesses are particularly vulnerable here because they tend to operate more informally, and many assume that because they're a small employer, probation gives them complete flexibility to terminate employment quickly.
But even where the small business fair dismissal code may apply in unfair dismissal situations, it doesn't eliminate exposure to general protections claims. Another thing employers underestimate is how closely courts look at decision makers.
Absolutely. And this one is huge because in litigation, attention turns to who made the decision, what they knew at the time, and what was being discussed internally, which means internal emails, Teams messages, and informal conversations can become very important evidence later to show what was in the mind of the decision maker.
Exactly. Sometimes the biggest issue isn't the termination itself. It's what was written internally before it happened.
We recently saw a matter that demonstrated this risk quite well, didn't we, Sonia?
We did. A business engaged a senior employee and placed them on a 6-month probation period. About 2 months into the role, the employee began raising concerns internally around operational practices and resourcing issues. Shortly afterwards, concerns were raised by the management about the employee's communication style and suitability for the role.
The business then made the decision to terminate employment during probation, believing the probation period gave them flexibility to move quickly and reduce risk. But the issue was the timing and the documentation. There was very limited evidence showing performance concerns before the employee raised the internal issues.
And from the employee's perspective, the argument became, well, I raised concerns and then I lost my job. The business viewed it as a performance and suitability issue. The employee viewed it as an adverse action connected to their workplace complaint.
What followed was a general protections dispute that ended up in the Federal Circuit of Family Court of Australia, and that became significantly more costly and time-consuming than the employer expected, despite the employee still being within probation.
And that's the key lesson. Probation itself didn't create the risk. The risk came from assuming probation removed the need for careful process, documentation, and lawful reasoning. So, practically speaking, what should employers be doing differently during probation?
The biggest thing is treating probation as a genuine assessment process rather than a legal safety net. And that means documenting concerns early, conducting proper check-ins, avoiding vague explanations, and ensuring managers understand the risks around protected conduct and workplace rights. The key message is that probation may reduce certain risks, but it doesn't remove legal exposure entirely.
Employers still need lawful reasons, defensible decision making, and appropriate process. Because when businesses lose these claims, it's often not because probation existed, it's because they assumed probation protected them completely.
If you're reviewing onboarding or probation processes, getting advice early can significantly reduce legal and operational risk.
Follow Legal on Demand for more conversations on employment and commercial law. If you have any questions or would like us to explore certain topics, please contact us via our website maguirelegal.com.au.
Thanks for joining us on Legal on Demand, practical law, real decisions on demand.